implementation of its housing policy. Now, I'm going to preface my submissions here by making a fairly obvious reference to what this court has repeatedly said to be the standard that applies when it comes to the assessment of socioeconomic rights. And that standard, as the court will be aware, was set in Bromwell, where the court said there that every step by the government in relation to housing must be assessed against the requirement of reasonableness in Section 26 of the Constitution. That has been the position that has been taken by this court repeatedly in cases involving socioeconomic rights, from Bromwell to TAC to Mazibuko, and in the context of housing, in occupiers of Olivia Road, it was then made even more clear in relation to housing that the requirement is that every step, and I emphasize that every step in relation to a potentially homeless person has to be reasonable. On the 30th of August 2016, the Bromwell families had just a week left before they would be evicted from their homes onto the streets of Woodstock. That was the reality that they were facing at that evidence, and we've dealt with this in our heads. Evicted from homes that they had been living in virtually their entire lives, in terms of intergenerational leases that went back to their grandparents. Now, the context, we've addressed the question of context in our heads, and as the court will know, again, repeatedly having been said by this court, for example, in Causa, this court said that context is all important when it comes to the assessment of reasonableness. And while I've dealt with this in my written argument, I just want to emphasize the context with which these individuals, these families, found themselves on the 30th of August 2016. This was not a case where these families or these individuals were being evicted because of non-payment of rent or because they had occupied their homes. Had been bought in 2013 by the Woodstock Hub. The business of the Woodstock Hub is focused on property development. It owns 1,200 apartments in Johannesburg and Cape Town, and it has made itself crystal clear that its purpose in purchasing the property was not to obtain rentals from the Bromwell residents. It made that clear in its affidavit that it was not economically feasible for it to do so. It purchased the properties for the purposes of converting them to rental apartments, with the middle income markets being targeted for rental in the amounts of 5,000 to 6,000 rand a month. Now, we'll return to this very briefly later, but I just want to make the submission at this point that the court will be aware that one of the points that we've taken in this matter is that the diagnosis of the Supreme Court of Appeal that defined the concept of gentrification as some form of urban renewal, we say was problematic. That what in fact happened here was precisely what the Special Rapporteur on Cultural Rights has said to be the consequences of gentrification, which is displacement. It's important at this stage to emphasize what then happened when these occupants of this property, the Bromwell families, approached the city for help. The court will be aware of the history of this litigation, the preceding litigation before that. Property was purchased in 2013. It was only transferred some time later to the ownership of the Woodstock Hub, but the notice for them to vacate was given before they were actually the owners of the property. But leaving that aside for a minute, I would emphasize that the socioeconomic context of what was happening in Cape Town at that time was critical, and we submit with respect that the Supreme Court of Appeal, to the extent that it had considered it, it's difficult to find any indications of that in the judgment. That in 2016, the undisputed evidence is that not only was Cape Town one of the most spatially divided cities in the country, but it was in the middle of one of the worst housing affordability crises in the world. Not in the country, in the world. In 2016, property in Cape Town ranked in terms of year-on-year property price increases third in the world behind Shanghai and Vancouver. That is the undisputed evidence of Ms. Royston. She dealt with what the consequences of that were in terms of housing affordability, and I will come later in the submissions to what the special rapporteur, what the Committee on Economic, Social and Cultural Rights has said in its general comment regarding the question of affordability. But leaving aside that for a minute, in relation to the practical consequences of what the effect of this was in Woodstock, the evidence again is undisputed. It was clear that in the space of less than 10 years, rentals in Woodstock and Salt River area escalated housing insecurity. And the court will also know that, as this court has previously indicated in other cases such as that forced removal is a shock for a family. It's not something they were experiencing at the time, facing potential eviction, having had no agreement. So that was the position that they were facing at the time at which they obtained access to legal assistance. At that point, the city was approached for assistance. The court will know that the constitutional obligation on the city when dealing with the basic needs of poor people is to respond to them reasonably. We submit that what happened at that point is indicative of what we say was an unreasonable approach of the City of Cape Town throughout this litigation. On the 3rd of September, a letter was written to the city, to the Directorate of Human Settlements and a member of the Mayoral Council. That letter came to the attention of Ms. Rihanna Pretorius, who is the Executive Director of Housing for the City of Cape Town, principal deponents to all the affidavits in this litigation. That letter pertinently drew her attention to what was about to happen. 43 residents, including 17 children, were facing potential homelessness and eviction. I emphasize here that that initial approach to the city was not simply to demand emergency accommodation. It wasn't phrased in those terms. Firstly, what the letter indicated was that there was going to be a meeting the next day. The city was invited to engage with the Woodstock Hub and the residents to try and come to a solution. That letter you'll find at page 105 to 106 of the record. It also drew the attention of the city to the fact that the Woodstock Hub had very clearly indicated that they were in fact going to execute the eviction order on the 10th of September. The response of the City of Cape Town came quite quickly, 2 days later on the 5th of September 2016. Now, we do not make the submission that the entire conduct of the city should be assessed based on one letter. We make the submission that in its initial response, the conclusion can only be drawn that its response was unreasonable. That response is at page 108 to 109 of the record. That is the response that was sent by Ms. Pretorius on the 5th of September. Ms. Pretorius' response that I wish to highlight. The first is that part of her response was that, well, in fact what had happened was that the court had taken into account a financial contribution by the Woodstock Hub. Now that could not be the case because of course that was not an issue that was even before the court at the time the eviction orders were granted. The second aspect of the letter is that apart from pointing out that the city's obligation to provide the emergency housing is only triggered when the respondents are faced with the threat of homelessness, what the letter then said in the penultimate paragraph is that the city does not currently have any emergency accommodation available for the respondents, but are willing to place the respondents on a waiting list for emergency accommodation should they apply and meet the criteria. Now, this was not a letter that was coming from an official that perhaps could have been mistaken about what the actual position was. This was a letter from the executive director of, acting Executive Director of Human Settlements. The one very obvious points that I point out at this stage is that the court will be aware right from the outset of the city's heads. In fact, if I recall, it's stated to be a matter of emphasis that emergency accommodation is not, according to the city, allocated on the basis of waiting. So it's difficult to understand with respect the basis on which Ms. Victorious could have concluded that they would be, that they do not have emergency accommodation available, but they will need to place them on the waiting list for emergency accommodation. In the answering affidavit that is ultimately filed on behalf of the city, there is an attempt to explain this by saying that at that particular point, all the facts were not before the city, and that was the basis on which the response was made. Of course, that doesn't deal with the question of the reference to the waiting list. Following from that, the court will then be aware, and I do not intend to take in the limited time that I have available through all the factual aspects of what then happened, the engagements regarding social housing, which span the record, I think, in excess of some 350 pages of the record. The ultimate conclusion of that is that none of the Bromwell families, in fact, qualified for the social housing, despite that lengthy process. There are a number of other aspects of unreasonableness that are dealt with in our case. That one of the aspects on which the High Court found that the conduct of the city in that respect was unreasonable was that the court will know that in relation to the Pine Road occupiers that were ultimately accommodated at the Pickwick Transitional Facility, it was made very clear when the city approved this that what in fact would happen in relation to the Pine Road occupiers was that the households, this is page 1537 of the record, it is proposed that households on the various sites will be consulted about a choice between the following options, and that page then lists a number of options. And crucial to that, of course, is that they would be consulted about transitional housing in that particular facility. The High Court pointed out that one of the aspects on which it was unable to conclude that the city had been acting reasonably was that those were not the same choices that were put to the Bromwell residents. We accept that there is an argument that suggests that the sport established in Blue Moonlight is the unreasonableness of that offer. In relation to the High Court's findings on the facts, we submit that what the High Court concluded in relation to the Pine Road, in relation to the Volvo-Field offer, and specifically, and I focus on this point because it is a practical consideration in a number of cases. For example, it was an issue that came up in Joe Slovo in Tubalisha. It came up in Barron versus Claytown in respect of transport. But what is common cause, and we submit the court would have to find on these facts, is that at the time, and this is dealt with in the affidavit of Mr. Russell and in the later affidavit in response by the city, that there was no public transport that was available directly from Volvo-Field to Cape Town. And what that entailed, as the High Court pointed out in its judgment, was essentially persons that would then have to take at least 3 taxis to get from Volvo-Field, assuming that they would then still have jobs in Cape Town, or if their children were still attending school in the Salt River area. They were seeking the eviction order had in fact tended to provide transport for the remainder of the school year. Now, there may be a response which says that, well, if one considers transport, but what the court will know is that in fact what happened is that the city took the view that it was not responsible to provide the transport, and that the Woodstock Hub, the owner of the property, would be responsible for providing the transport. The next point that I make in relation to the question of the emergency accommodation is related to the issue of exclusion, the exclusionary effect of the city's, I would call it in inverted commas, policy position that emergency housing is not provided. In relation to that is similar to that made by the submit with respect inevitable. The outcome of the offer, in this case Walborough, all IDAs, the city made it clear, can only occur to an IDA or a TRA. It's common cause that all of the IDAs and TRAs are located on, and that in those circumstances the outcome would always be that in circumstances where the policy position is that emergency accommodation as a matter of course is excluded from the city, it would then be to the TRA or the IDAs that the city has determined. I want to then turn to the third theme, which is the answer. Essentially what the city has put up as the answer and what the Supreme Court of Appeal held was the basis on which the declaratory relief and the structural intake granted by the High Court, and in addition the order that was granted that the occupiers, the Bromwell families, had to be provided with accommodation in a particular area was wrong. The first is, and I will deal first with the question of resource constraints because it relates to what we submit with respect should be the proper standard of reasonableness that applies where an organ of state relies on resources constraints to suggest or to argue that it has acted because the court was dealing with the question of whether permanent residents should be entitled to social